Bonjour and welcome back. In this video, we will discuss a subcategory of patrimonial right, personal rights. I will discuss real right in another video. Personal rights are oftentimes referred to as obligations, and they will be the core of your course of the law of obligations in the spring. Here is the definition that is given in the Louisiana Civil Code at Article 1756. You will be able to read it peacefully, opening your code or looking at the slides. Uh, let's be analytical and see what we have. I'll try to unpack Article 1756 or access its DNA, as I like to say when I analyze Civil Code article. It is telling you in substance that a party called the obligee, who could be designated in other legal systems as a creditor, has a right to demand from an obligor or debtor a performance that may consist in giving. By giving, the law means transferring ownership. The word is misleading because you think of a gift, but it is not what is intended here. It's the idea of a passing on, transferring ownership, making the buyer the owner of sold property, for example. The obligation may also have as a performance doing something like delivering a thing that has been sold, or painting a house, or writing a book, whatever you have to do, typically under a contractual obligation. And not doing, which is a little bit counterintuitive. Why would you contract not to do? Well, in a contract of employment, very often the employer has the employee promise not to reveal trade secret or not pass some valuable information to the competitors. This is an obligation not to do. And this giving, doing, and not doing business that you have in Article 1756 of the Louisiana Civil Code finds its direct origin, of course, in the French Civil Code of 1804, but further up the road to Roman law, where they were talking about dare, and dare means you transfer, facere, to do, and non facere, not to do. Let us see now, and I told you we'll try to get into the DNA, or at least the molecular analysis of the obligation. When you think of obligation, you think of duty. You think of something you have to do, which would be a sort of one-way street, right? But in the law, things are more complex, and you will study that in depth in your course of obligation. Obligation is a two-way street between the obligor and the obligee. The obligor owes a performance to the obligee, and that is the duty part as you see it. But the obligee owns actually a personal right that can be enforced against the obligor with all kind of legal actions. And by the way, remember the Gaius Institute distinguishing persons, things, and action. By action, they were thinking of the obligation, all the recourses that an obligee or creditor of an obligation has towards enforcement of the obligation. Okay. And this describes the personal relationship between the obligee and the obligor. So when you look at obligations in the civil law, we mean a what we call a credit right, which makes up what we call the active side of the obligation. That's the perspective from the point of view of the obligee. That looks a little bit confusing. Let's try to clarify. And by the way, you will have an entire semester to study this in more detail. Obligations or credit rights are patrimonial rights. They are entries in the patrimony of the obligor and the obligee. If you look at things from the obligee's side, the obligation is an asset in the obligee's patrimony. That's the active side. You have the right to sue the obligor to obtain something, a performance, giving, doing, not doing, or monetary compensation, damages in case of non-performance. We say the active side because you can start legal action to recover what is due to you. The liability, from the obligor's point of view, it is a liability because the obligor has to do something, owes something, money, or doing something like painting the house or painting a painting, why not? Writing a book, etc., or showing up at work every day if you're an employee. It's a bit counterintuitive to call it the passive side because the obligor has to be active, except when the obligation is not to do. But we call it passive because in case of non-performance, you just wait and see and hope you're not going to be sued and asked to pay something. You'll be the defendant in the legal action. And obligations or credit rights are seen also as personal rights. Remember that personal rights are a subcategory of patrimonial rights. It's personal in the sense that the obligor owes the performance to the obligee only and not to the whole world. And the obligee's credit right can only be enforced against the obligor. It's the obligor only that has to pay damages in case of non-performance. Here you have an example just to view the obligation as entries in the obligee or obligor's patrimony. Imagine that a seller sells 100 tons of raw sugar cane to B at a price of $300 a ton, payable 90 days after sale. In this example, the seller is the obligee of the obligation to pay. The payment is due to the obligee, and the buyer is the obligor of the obligation to pay. So in the seller's patrimony, you have an asset, okay, which is the credit right to be paid 30,000 90 days after sale. Though the payment is not received, you have an action in payment in case the buyer defaults in making the payment. And in the buyer obligor's patrimony, you see that you have a liability. It's not money that is owed now and then. It's owed only at a term of 90 years, but it is nonetheless a liability in the patrimony of the obligor. Let us now look into the sources of obligations. How do obligations come to exist? Which again, you will study with much more detail in your obligations class. According to Article 1757 of the Louisiana Civil Code, you have here actually the text broken down into categories. Obligations arise from contracts and other declaration of wills. They also arise directly from the law, regardless of a declaration of will, in instances such as wrongful acts, think of torts, the management of the affairs of another, unjust enrichment, and other acts of facts. We'll be a little bit more analytical in this, but I want to show you that based on the modern categorization of obligations, you're getting this, a distinction between juridical acts and juridical facts. You see that there is only one letter differentiating them, at least in the English language. It's a distinction that is coming from German scholarship. It has been borrowed by the French and has moved all the way to Louisiana. And you will understand in a moment that it is reflected in Article 1757 that we just viewed. Take a deep breath and let's be now more analytical. Juridical acts are typically contracts, or they can be other declaration of will that are intended to produce legal effect. What is characterizing the juridical act is that you have an act of will. You have intent, which is directly driven at producing some legal effects. And the paradigm, I mean, the model is contract, but you will see along the way that you can have other declaration of wills that can produce legal effect, like acknowledging a child. You recognize that the child is yours, and you consent to all the legal consequences that this will have. Juridical facts, however, are facts that happen. They can be facts of life, or they can be facts which somehow connect to a will or a human project or conduct. But as we will see, they are not, the intent is not driven to the legal consequences that they will have. That includes the large category of wrongful acts that you study this semester as torts. So you're already studying obligations in a sense. And these wrongful acts can be intentional, delicts or offenses, or intentional torts, as they are called in your class, or negligent act that in Roman law we would call quasi-delicts or quasi-offenses. That's the word that is used in the Louisiana Civil Code. So all torts may correspond to intentional activity, but when you do intentional killing, it's not with the intent to give compensation to the widow or the children of the victim. Okay, the intent is just to deprive someone of life, and that can have all kinds of unintended consequences, like serving time in jail or being sentenced to death and having to pay all these compensation. You have other juridical facts that I'm going to detail in a moment, and are the classical terminologies to describe them as quasi-contract, because one applies sometimes the law that has been developed in the context of contract, though they are not contract per se, but derived from fact of life, and that includes management of affairs, or enrichment without cause, also called unjust enrichment. I will get there in a moment. And you have other facts like the birth of a child. There may be intent behind it, or it may be an accident of life, okay, but that's going to have or generate all kinds of obligations that will exist, by the way, regardless of the intent behind the birth of the child. So if we go back now to the sources of obligations, you will see that they somehow reflect these contemporary classifications that we have just seen, because you have juridical acts where the legal effects are intended, contracts that you will study in the law of obligation. You will have the civil law side of that topic that you study under the common law this semester, and you have a full Title IV dealing with the general law of contract, and multiple title dealing with special kinds of contract that you won't have the time to study in the obligations class. That's why I only point to Title IV, and other declaration of will that generate intended obligations, like the acknowledgement of a child. If you acknowledge the child, you pretty much know that you will have to pay for the education of the child, or the acceptance of a succession. You are free when you inherit to accept or reject the inheritance. Sometimes it's not in your interest of accepting the inheritance when the amount of debt exceeds the assets that are to be found in the succession. You may say, oh, no, 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 because the moment you accept, you may be out of pocket and have to pay the creditors of the deceased. So, but you know that when you accept the succession, you will cash in the assets, but you will have first to pay all these liabilities, all the debts of the disease. And this is pretty much what you accept when accepting a succession. So your will is driven to these intended consequences, to these intended legal effects. I come now to juridical facts. And we use here the word fact because they are facts of life. They are not acts where you are acting and projecting to the legal consequences. Here, the legal consequences will occur no matter whether you intended them or not. And the first category that I mentioned a short while ago are offenses and quasi-offenses, as they are called in our civil code, delicts or quasi-delicts, as they are called in the French civil code or in Roman law. Here you have the whole law of tort. And you have, and I will now be a little bit more analytic, with these obligations that arise without agreement that are sometimes called quasi-contracts because one uses chunks of the law of contract to regulate them. Management of affairs of another is dealt with in Article 2292. These are situations where the owner of some property is not capable of taking care of the property. Imagine we have multiple hurricanes coming to Louisiana this season, and you see that your neighbor is not there. There is a hurricane warning, and the hurricane is coming and stripped the roof from your neighbor's house. The neighbor is not here to take action. You may actually, as a good neighbor, buy a piece of tarp and cover your neighbor's roof at your own expense. Should you be on the hook for that expense? You're taking care of the affair of your neighbor. Of course, the best conduct is to call the neighbor, text message or phone, but we all know that in these events, we may lose circuit and the neighbor may not be reached, and you act. The law will say that in such a case, the neighbor whose affair has been managed by another owes a payment and will have to pay for the tarp that has been purchased to preserve his property, provided, of course, that the measure taken is reasonable. There is plenty of law on management of the affair of another. You see, by the way, that the civil law is encouraging, good Samaritan attitude, be a bit altruistic. That's the community feeling that exists in the civil law and that you don't necessarily find in the more individualistic common law. Another example is unjust enrichment or enrichment without cause. Sometimes you are enriched and at the expense of another. And if the conditions that are set in Article 2298 are met, you will actually owe compensation to the one who's been impoverished. And I told you that there are other situations that can qualify as juridical facts in the law. I'm giving here, among others, but that's not the only one, Louisiana Civil Code Article 224, saying that parents are obligated to support, maintain, and educate their child. The obligation to educate a child continues after minority is provided by law. It's the law that is fixing that obligation, is giving contour. So it's giving actually a right to sue to the obligee of such obligation. And if you want, you may look also into Article 237 and 38, where you'll find other examples. So all these obligations, I insisted already in the previous video, are personal rights. And let me again insist on what it means. Obligations are rights having effect between the parties. That's what the word inter that is used every so often, forgive my Latin, pardon my Latin, one person is subjected to the other, okay? It's only existing between obligor and obligee. However, as we will see, or you will study more in detail in the law of obligation, it is typically the patrimony of the debtor that is subjected to the authority of the creditor. You have, of course, situations where you may sue for specific performance, and then the specific performance is very personal in character, but most of the time you're getting damages, you're getting money compensation in case of non-performance, and this whether the obligation is to give, to do, or not to do, which means that ultimately at the end of the day, the responsibility of the debtor or obligor is financial. It is paying damages. And for the payment of damages to be possible, the law is giving the creditor a general pledge on the property of this debtor. And here I'm going to disclose a very important article in the Civil Code, 3133. It's almost at the end, but it's almost as important as the first articles in the code. Whoever is personally bound for an obligation, so that means any obligor, is obligated to fulfill it out of all of his property, movables and immovables, present and future. What does it mean? It means that in case of non-payment of the damages you owe because of non-performance, the obligee or creditor can get at any of the assets that will be found in your patrimony at the time when the judgment will be enforced. So they can get hold of movable, immovable monies that are found on your accounts, anything that qualifies as assets at this very moment of time. This is why it says present and future. Okay, so actually everything you have, all the assets that you have, serve as a collateral to guarantee the payment of your creditors. Of course, it's not sufficient because oftentimes people are facing insolvency, and obligees or creditors like to have more sweets in their pocket, and they like to have security devices to strengthen their personal right. So, and we will study this in the next video, you may combine a personal right with a real right, called commonly security devices. And this way, whomever is lending you money under a credit agreement or a loan may wish to have a real right, for example, on the car that you purchase with the money that you borrow. The bank will keep a lien on the car, the right to repossess the car, and have preference over the money got, over the resale of the car, and the bank will be preferred to all other creditors. The same goes with mortgage, but we will discuss that in the next video. I hope this is clear. I know that these slides are packed with tons of information that are central to lawyering, okay? And you will meet them in countless examples when you study the law of obligation, when you study sales and leases, when you study property, etc., whichever part of the law. Thank you for your attention.